And
All right, it may take a minute before people trickle in.
it's nice when we do come on, you guys, early so we can kind of catch up with each other. I'm glad you did.
Yeah.
I'm glad everyone's here.
Is Victor not coming?
No, Victor, yeah.
He had a
Kids
conflict.
are on break too, probably.
Uh,
Yeah.
I think he said he
No.
had a meeting conflict.
yeah. He let us know that a couple of weeks ago. There was some kind of a conference that came up and he had to attend.
We're up, Brian.
Yeah, I think we can start.
Okay. All right, then we'll go ahead and call our meeting for March 25th, 2021. And we are meeting by Zoom conference. And this is, let's go ahead and take the minutes in order, or the agenda in order. The first item is our minutes. Anyone want to move to approve?
I move to adopt the minutes.
And
Okay,
no staff corrections.
perfect. Okay, so then we've completed that. Those can be entered as the meeting minutes from February 25th. And then let's go ahead and take the second item, which is administrative matters.
I would suggest that we put the California Style Manual issue over to our next meeting so that we can have a full complement to consider it.
Is that acceptable?
Sure.
I mean, it's fine. Who's missing? So we have one.
Victor.
Yeah,
Victor and Kara,
yeah,
both
we're just
people who
we're just-
expressed interest.
yeah,
at the
Kara.
last
Oh,
meeting.
that is true. That is true.
I'd hate for something to happen without them having a chance to participate. So let's
No,
wait.
that's fine. That's fine.
The California
so
Style Manual will wait.
Okay, that's fine. That's fine. But the second item is just a report of the executive director. That's the
Yeah.
first one. Okay.
So, good news, bad news. The good news is that Steve has completed his public service as a contact tracer and is back full-time now.
I know
unless-
you're gonna be sad.
So you'll be seeing more of him. Bad news, which is not terrible, but as was just said, no Commissioner King or Jenkins today. Both of them have other obligations. We also will not be seeing Staff Attorney Kristen Burford today. She has a well-deserved break this week. Her kids have spring break from their school, and she's taking an advantage just to have some family time. And then one bit of bureaucracy, if you haven't already done it, you should look to complete your Form 700, the FPPC Statement of Economic Interest. That is due on April 1, and they do issue fines if you're late. So make yourself a note. That's all I have on the Executive Director's report.
And if I can just add too, that you can do the Form 700 online, which makes it
Mhm.
very easy. And then also too, I thought our ethics training is due too. I took it.
Well, everyone's on a slightly staggered schedule on that one because it's every 2 years per person.
You guys are good right now, I think most of us. All right, so any commissioner suggestions?
And we're tabling memo 13 until the next meeting.
Right.
Okay, Commissioner Rubin, you don't have anything?
I have nothing, to say beyond what I have, and thank you for asking.
Okay, good. All right, let's go ahead and go to agenda item number 3, which is the 2021 legislative program.
Yeah, we didn't have a normal legislative program last year because of COVID. Our bills got pulled. So for the most recently appointed commissioners, this will be your chance to see what a legislative program looks like ordinarily. And it's been pretty busy. So there's a main memo and 2 supplements. The supplements correspond to our bills on the California Public Records Act and a collection of proposals related to trial court restructuring. Barbara will be presenting on those, and I will handle the main memo. The resolution of authority, as the table that's attached to the memo shows, was approved on consent. So that's moving along fine with no issues. And I'm taking these in bill order. The next item up is Senate Bill 315 by Senator Roth. This is the bill to implement our follow-up study on the revocable transfer on death deed. This bill was amended on March 15th to make 2 changes. The first was actually a change that the commission proposed. If you remember at the last meeting when we were talking about stock co-ops and transfer on death outside of probate, we identified an improvement that could be made in that context and realized that the same change in the RTOD deed statute would be an improvement there as well. And so the commission directed me to talk to the author about amending the bill to include that change, and that was done. So you've already approved it. The only decision up for this item is that I've presented a draft comment on the second page of Memo 2114 for that change. And if the commission can approve that comment, then we will include it in a supplemental report that we issue with revised comments. Any concerns about that language?
No.
I'm
Nope.
seeing positives all
approval.
around. Okay, good, thank you. The other change was prompted by legislative staff who wanted there to be sort of an express provision to dispel all doubt that the proposed law would not have any effect on otherwise existing penalties and remedies for elder financial abuse. I don't think there was any way to see the RTOD deed statute as having that effect, but disclaiming it is therefore no problem at all. So that language, I didn't even bring it back to the chair because I think it's declarative of existing law and it's not something that's part of our proposal, so we won't take any kind of ownership or endorsement of it. But just to give you a heads up, and that was language that they added as section 5698.
It's basically belt and suspenders.
Exactly. That's what's in my notes. Yeah, it's on page 2, 5698, towards the bottom of the page. So no action required on that one, just a heads up. Then that's it for that item. No, I'm sorry, there's one more thing. There's a lot of activity around the bill. As we expected, there are concerns from the Land Title Association, there are concerns from the California Lawyers Association, Trust and Estates section. And so there are conversations going on between the author and committee staff and interested groups about whether to make changes to address any of the concerns that people have. I have been an observer and participated in some of those, but they're confidential, and so I'm not free to discuss them, except that I did ask for and get permission to just very generally describe one issue and see if anybody had a strong reaction to it. You'll recall that in our proposal, one of the changes that would be made to the statute would be to require that a beneficiary give notice to the decedent's heirs before the title to the property transfers to the beneficiary. So that would give everyone notice, everyone who has a potential interest in the property, notice that they need to act quickly if they want to contest it before it operates. That provision was modeled after a rule in the trust law. And when the bill was before the legislature, it's pending a hearing in judiciary, one of the analysts looking at the bill noticed that we included language on the potential liability of a beneficiary for a breach of their duty to give that notice. And the commission specifically decided that the duty should be not too strict. The language in the proposed law says that a beneficiary is liable to heirs for a breach of the duty to give notice if the breach was intentional or grossly negligent. And my recollection of the discussion when we approved that language was that because beneficiaries are not fiduciaries like trustees are, and could be just anyone, just a layperson who happens to be named as the beneficiary of one of these deeds, we didn't want to impose a duty that was going to have really strict liability on that person and potentially expose them to a large scope of liability just because they made a mistake. So we included that language about the liability existing if the breach was intentional or grossly negligent. That caught the eye of the legislative staff, who they were not too sympathetic. They understood what I had to say about the trustee being a fiduciary, and so it being appropriate to have a lower standard here. But they thought that reasonableness was an appropriate standard. And so there is interest in changing the law in that way to remove this more generous standard of responsibility and replace it with a reasonableness standard. And the reason that I want to be sure to bring that up to you, it's not a huge change, but it is directly contradictory to something that we discussed and decided. And I wanted to give you a chance to let me know if you thought that that would be so problematic that you'd rather not have the notice requirement at all. You talking about belt and suspenders, you know, we added the notice requirement as a fraud protection. We added witnessing as a fraud protection. We didn't really find any special evidence of risk of fraud with these instruments. So we were being very protective in our proposal. And so peeling off one layer of protection would be a change and a significant one, but it wouldn't necessarily leave it fully exposed. And so I'm not inviting this or suggesting it, but I just want to give you a chance to let me know if you think that imposing a higher level of potential liability on a beneficiary who makes a good faith mistake is, in your eyes, a greater harm than not having the protection at all. And if so, then I would share that with the author and they could put it in the mix of considerations they're looking at in deciding how they want to proceed. Does anybody feel that way?
You know
And
what,
I'm
and
fine
then
with it.
are you, and then Jane, you know, I was just thinking for the reasonableness standard, that's weird. And that's not something that is typical of the probate statute. So I don't know if that judicially, that's not necessarily a good move. If they want to change the law to say that, that makes sense. And then, but maybe we should just back off of it altogether though, Brian.
Well, that's what I'm trying to get a read on that.
Yeah.
I'm
I
fine with
heard
the change.
Commissioner Carrillo say he's fine with the change.
Yeah.
The chair is.
I mean, it kind of splits the baby. You know, we went very protective. You know, the other end of the spectrum is not very protective at all. You know, this is kind of a middle path. I'm fine with that.
Well, it sounds reasonable, but the problem is that when you deal, so if you're, so you figure, where are these matters going to be heard? They're going to be heard in a probate court. In a probate court, they rely on the same standards. They have a judicial standard. So to insert another standard that would be fine in like a civil court, that is very strange. And to me, that if I could see this matter becoming an issue before like a Supreme Court, I don't necessarily want us to make a change like that.
Commissioner McAllister was going to say something.
And no, I was thinking about it. I mean, I've been thinking about it. And I think I almost would, I'd like to hear from the other commissioners that don't have a background in this at all, because I want to hear what you think it means just to a layperson or to someone who's going to be involved in this process. I didn't have a problem with the language, but I would just like to hear what other people think. And if they think it's problematic to put it in, they feel it should be something that a legislate is in how Crystal had proposed to do it, that's fine too. I mean, I think this whole, there's so many permutations to this whole process to begin with. So it's like, what do you pick? How do you do it? If we do it too conservatively, then okay, then they're all like, 5-alarm fire, don't do that. But if we put nothing in there, then I guess it just ends up being litigated. you know?
Well, if we
Yeah.
put nothing in there, then it would rely on the judge's deference.
Which could
if
be
it-
all over the board, depending on where you are. So
Yeah,
if you have a situation where you have a good faith effort by somebody, but the judge decides he doesn't like it and they're going to get just hammered, right? They don't have any recourse. I mean, they don't, I guess what it does is it just becomes a case by case basis, which I'm
Yeah,
not saying.
I don't have a
bad.
probate background, but across the board, I'm usually going to disfavor case by case extreme judicial discretion scenarios.
I don't like it.
Yeah,
I
so
don't like it.
that's why I said, like a middle path, I'm okay with that, in this context. Again,
But
not
a
having a
reasonable-
probate background.
Yeah, but the reasonable standard is not a middle ground. That's like a whole different, and I just say this just as like a former like judicial clerk. That is something they would look to legislative history to figure out how on earth did a whole new standard come from? Where did it come from?
And
You're
legislative
nodding
history is
too,
going to
Anna,
include
right?
our comments.
Yeah, it wouldn't make sense. And I don't think we just agreed because one of the stakeholders said to do it. I think we just don't touch it because I get what they want, but they would have to do that statutorily. We wouldn't, I don't know.
Do you feel like it's something we can clean up with a comment? Because you mentioned that they're going to look at legislative history and, we can affect that.
We don't have a comment.
I mean, if the change is made, could we help with a comment?
Yeah, that's what I'm saying.
Well, it
Do you-
depends on how, I don't know how they're thinking of drafting it. I mean,
Yeah.
it's possible that the solution would be just to delete the standard we've proposed, the lower one, and just be silent and let general law control.
We could do that. Do you think that this is something that Kara would be helpful in weighing in on? No.
Oh,
I don't think so. I mean, Diane's general position, or when she was a commissioner, was that she was uncomfortable taking positions on political issues because she has a duty to every single member of the legislature. And so she didn't like to take positions on divided issues.
I think we should back out of it.
How does everybody else feel?
There's logic to both arguments.
Not insufficient data to decide for me.
It's challenging. I agree.
And my question, Brian, is this staff member that gave you that feedback, is that going to be a major obstacle if we don't go along? Or what is the political, practical implication?
That's a good question.
Yeah, it's hard for me to speak too freely on this because these are discussions going on within the legislature itself. But it's my sense that the change will be made. That people are pretty insistent about it. And so the question for the commission is, on balance, do you think it's better to let that happen or ask that the whole protective scheme be pulled out, which I think would be kind of a
That'd be
dramatic
extreme.
response.
Right.
I mean, we
And-
could have a comment that said that we relied on tenets of probate law but we'll defer to them. I mean, I don't know, but it is something that they should consider.
So maybe it would make sense to bring this back at the next meeting. If the amendment is made, then we'll have actual language. And if the solution is to craft a comment to clarify the commission's intent, then we would have real language to respond to rather than just sort of an abstraction.
That was
Understood.
that was going to be my suggestion, which was, I think we're not ready yet to decide it. I think we need to hold off.
Okay. Thank you. That's sufficient. And that's it for that bill. The other bill that's seeing a lot of activity is SB 391 by Mr. Chow. And this is our bill on meetings and common interest developments during emergency.
Yeah.
And you'll remember the point of that bill was to waive the in-person requirement during emergencies if the CID conducting the meetings meets certain standards of conduct, to make sure that the fact of the waiver doesn't unduly prejudice the rights of members to participate in those meetings. The bill drew opposition. And the first group in opposition was California Center for Homeowner Association Law. I think I'm getting that name correctly. Marjorie Murray, who's a regular participant in our process during the development of this proposal, is the president of that group. And the opposition is grounded in some issues that we heard her raise during our process. Later, the opposition was joined with nearly identical letters from California Association of Retired Americans and Habitat for Humanity. Those groups had I believe four main points of concern. One was about the fact that we didn't change the rule on delivery of notice of meetings. The existing law says that notices are to be general, which means you could simply post them, except that by law, members have the right to opt in to individual delivery of general notices. So if you wanted to receive mailed or emailed notice of these meetings, you had that right. The opposition groups wanted that to be the rule across the board, individual notice of these meetings. An amendment was actually made to address that concern in the Senate Housing Committee. The author accepted the amendment, and it sort of split the difference in that it would require that the first meeting conducted under these processes for a particular emergency would be by individual delivery. Subsequent meetings would be general. And that the notices would remind the members of their right to opt in to receive individual notice of all notices. There was another change, so that change was made, and I believe that the opposition was happy with that change. Not everyone is, because it adds costs. The other change that was made, which I believe is still sort of under examination by the committees, was to provide that if the association had reason to believe that the emergency had displaced members, so they were no longer in their homes, then there'd be a duty to take reasonable steps to find an alternative way to get notice to them. So like if I ask for mailed notice, but I'm not in my house anymore, and you know that, then mailing me notice wouldn't be sufficient. You'd have to look to see if there was another way to reach me. So that's the notice issue. And like I said, I think that one has been mostly resolved, although that last piece might still be in flux. The other issues have not yet been addressed. And I'm going to be careful how I talk about them because, Ms. Murray is in our audience, and I don't want to say anything during this meeting that is going to prejudice the author's consideration of these issues by, unduly taking a positive or negative position with response to what's been proposed. So I'm just going to describe it for you, and you can take it into account. If anyone has strong feelings about it, let me know, and I would pass those along to the author. But again, bear in mind that these are in progress, and we shouldn't do anything that's going to sort of put a thumb on the scale where the author wants to exercise their discretion without that constraint. So the other three issues, one has to do with the counting of ballots in a CID election. And we heard about this. The existing Davis-Sterling Act includes a section that provides that when ballots are opened and counted, that it has to happen at an open meeting of the association at which members can attend and witness the process. And concerns were raised about the adequacy of using teleconferencing for that purpose. And the opposition groups raised that issue again in the legislature, and I believe would rather that the law simply, our proposed law simply not apply to meetings at which ballots are counted. when this bill has been double referred, which means that it has 2 different policy committees assigned to it. Fortunately, it hasn't been flagged fiscal, so it doesn't have to go through 3 committees in each house, but 2 is a heavy lift. And so it was heard by Senate Housing as the first policy committee. It's going to be heard by Senate Judiciary as the second committee. And when we had the hearing in Senate Housing, a couple of the members of that committee mentioned that they were also members of the Judiciary Committee, and we're going to be interested to see the bill again because they had some concerns about the issues that hadn't been addressed by Housing, these other 3 issues. And notably, one of the senators who made a statement along those lines was Senator Wajkowski, and he indicated that he had been the author of the bill that added the requirement that ballots be opened in a meeting that's subject to witnessing by members. And so he has a particular interest in protecting that rule. And he actually, because of that, abstained from voting on the bill in the Housing Committee. He's going to reserve his vote until Judiciary, and the sense I had was his decision in Judiciary was going to be based in part on how he felt we had addressed that concern about opening ballots. So that was one of the issues that remains to be resolved. Another one was the availability of civil enforcement remedies in court for a breach of the requirements of the proposed law. Because we drafted the proposed law so as to put the new section outside of the existing article on board meetings, in part because we wanted to create a new location for emergency provisions, but also because the procedures apply not just to board meetings, but also to member meetings. And so putting it in the article on board meetings might be an odd fit and might lead to confusion. But because we did that and put it outside of the article, it's not within the scope of application of an existing section that allows members to sue to enforce the requirements of that article. So the rules that govern board meetings, members can seek judicial enforcement of those requirements. And because our proposal's not in the article, it's not covered by that section. And we discussed this at a prior meeting. And my informal suggestion was, let's bring this back. That issue should be addressed more carefully, and the commission could look at it after we find out what happens with this bill, which we didn't want to slow down. Nonetheless, that issue is back now in the legislature, not in the commission's process. And so that's another issue that I think is going to be addressed one way or the other in the Judiciary Committee. And then the final issue has to do with making recordings of the meetings. The provision does not require that we drafted, but the opposition wants it. They want a legal requirement that if you proceed under these special rules and you have a meeting without a physical presence, physical location, that you make a recording of your video conference and you make it available as a record to the members. Members have the right to inspect association records, so members would have the right to watch that video. This was suggested in an earlier meeting, and the commission decided against including it, in part on my recommendation, because I pointed out that that's not an existing requirement for CID meetings. If you hold a meeting in person, there's no requirement that you videotape it and make the record available. If you hold a teleconference meeting under existing law with a physical location, there's no requirement that you videotape it. So the requirements would be stricter for this special procedure than ordinary. And, sort of the guiding principle I was recommending when we were developing this proposal is that the procedural requirements that we attach to it be limited to those things that are necessary to obviate potential harms of holding a meeting without an in-person component. So if holding a meeting without an in-person component would cause a problem, we would add language to cure that problem. And since nobody currently has the right to record meeting, to review a recording of CID board meetings, it didn't seem like adding such a requirement in this proposal was necessary to obviate any kind of problem that would be caused by holding the meeting without an in-person component. With respect to that issue, the outcome would be exactly the same as for any other meeting under existing law. So that was the argument, and the commission decided against including such a requirement, but the opponents are seeking it. And I think that too is something that's probably going to be addressed one way or the other in the Senate Judiciary Committee. I think, hold on a second. With respect to the first issue, the notice provision, again, I think that we might want to wait until the second house and the language is firmer before we make any decisions about drafting comments to reflect the changes that the legislature made. With respect to the other three issues, they are still in the air. There's no concrete amendment yet with respect to any of them, and so there's no conforming comment revisions for us to make. If the commission felt really strongly one way or the other about any of those issues, exempting ballot counting meetings, adding applicability of the existing meeting enforcement rules in court, or requiring recordings for these meetings, you could tell me that and I would pass it along to the author. But like I said, in this instance, the politics are difficult. As with CIDs generally, the memories come flooding back. It's hard to find compromise and consensus on these issues. And so I'm reluctant to complicate the author's job by having us sort of throwing things in from the sidelines as he's dealing with discussions with the opponents, those who support the bill but wouldn't necessarily support these changes, committee staff, members of the committees. So if any of you have a really strong feeling like, no, that change, that would not be consistent with what we were trying to do, it would be antithetical to what we're trying to do, I don't think that should be done because it's just incompatible with our recommendation. If you had that view, I would pass that to the chair. But if it's at the level of, well, leave well enough alone, do what we recommended, we thought about it, that kind of thing, I would rather stay quiet. Does that make sense?
Jane, you wanted to say something? No. You know what, Brian, I would just say that, okay, so what?
Let me point out there's a hand up in the audience if that affects whether you want to say something now or wait till you have a chance to hear from them.
Yeah, let's see, who has their hand up? I see one hand.
Tom,
Oh, okay.
sir.
Let Tom go ahead and speak.
I
Tom?
will allow him to speak. We're in the process. You have to unmute yourself, sir.
Okay, I think I just did. Can you hear me?
Yes.
We can, thanks.
Okay, my name is Tom, sir. I'm on the Legislative Committee of the Center for California Homeowner Association Law and have been working on those amendments that Brian has discussed. I am also a retired Superior Court Commissioner, and during the time that I was active, I did serve for 6 years on the Judicial Council's Advisory Committee on Civil and Small Claims. And in that capacity, I worked with this commission and its staff on a number of issues. And I developed a great respect for the importance and the excellence of this commission's work. The fact that most commissioners and all employees are prohibited from advocating for the passage or defeat of any legislation, I believe is essential to maintaining the credibility of the CLRC. And so I had growing concerns as I witnessed the involvement and the nature of the involvement of commission staff after SB 391, authored by Senator Min, after that bill was introduced and sent to Senate Housing. Specifically, this is what I witnessed that really troubled me. First off, on March 12th, representatives of our center met with Senator Min's office to discuss our concerns about the bill as it was introduced. And I was surprised that commission staff was present at that meeting and essentially steered the conversation regarding the amendments that we were seeking. And then secondly, there's an event that's noted in the staff report before you, which indicates that prior to the Senate Housing Committee meeting on March 18th, staff had met with the chair of the Housing Committee to discuss amendments being sought and quote, and possible responses to them, end quote. It sounded like lobbying to me.
Well, that's
finally, at the hearing itself, commission staff was introduced and spoke as the lead witness in support of the bill. All of these seem to me to constitute a violation of Government Code 8288 and compromise the reputation and credibility of the CLRC. And so we ask that staff not continue in this advocacy role as SB 391 moves forward through the legislature. I think there's some additional comments by Ms. Murray.
Before we proceed with Ms. Murray, I feel like I need to answer that, in part because one of the things he said is just not correct. I did not meet with the chair of the committee or discuss amendments with the chair of the committee. I've never done that kind of thing. We do work with the author's staff at their request to assist them in understanding issues and how they relate to the commission's recommendation. We've been doing that for 60 years. The phone call Mr. Sir describes, I didn't know he was on it, actually. I thought it was Marjorie. But it was, the phone call was with the staff from Senator Min's office and Marjorie, and the senator's staff had asked that I be part of it. I guess Marjorie had asked that I not be part of it, but the senator's staff wanted me to be there. And, you know, we talked things through. The letter that had originally been sent was unclear in some ways. One of the claims it made was flatly false. And in other areas, it wasn't clear exactly what the group wanted. So I was there to help the senator's staff just sort of talk through the issues as a subject matter expert. And like I said, we've done that kind of thing for decades. And I was not advocating for passage or failure of the bill. I was just providing background information. I also did testify at the hearing, and I don't remember exactly what I said at the hearing, but again, that's something that we have done consistently for decades. And the standard that we always take is that we are there to explain the commission's recommendation and be available to answer questions. And that's what I did. I didn't advocate for passage. I didn't advocate for or against any kind of change to the bill, even though proposed changes were on the table. I just explained, I think, if I recall correctly, it's recorded, so I could go back and double check. I just explained that the commission's goal was to waive the in-person requirement during emergencies, subject to procedural requirements that we propose to mitigate any problems that might result from a waiver of that requirement. And I think I also said that we were inspired to do that by our own experience with the Bagley-Keene Open Meeting Act and how critical it was to have the in-person requirement waived. So I think that's, you only had 2 minutes, and I think that was about the sum total of what I said. If commissioners would rather that staff not do that kind of work with authors. We could revisit that. I think it wouldn't be a decision to make today, since I'm being surprised by the concern, and I'd want to take more time on it.
If
But
I
it
can
has
just
been a-
say to Brian, I've worked with the commission since 2011, and we have been very, very cautious, which I have learned it is always in our interest to do. I mean, we've been doing this, like you said, and I would not even necessarily put the proposal before the commission to withdraw staff's role in bills and writing proposed legislative changes. That's part of it. The body has always served to be an advisory resource. And so we wouldn't change it because someone didn't necessarily understand or appreciate staff's participation in that process.
Second that.
Okay.
I second that. Well,
And I wouldn't even
third
spend
that.
time going back and looking in the minutes of what happened, Brian. I would not want our resources to speak, because it is public. It's a matter of public freedom, the Freedom of Information Act. It's available, it's accessible, and that's just our role.
And as I will third that, as someone who worked in the state legislature for almost 40 years and who worked for 9 different assembly speakers, what Brian did and what Brian does is exactly what the leadership and the members of the legislature need to have in front of them, is the type of expertise to help them understand and to make the decisions they need to make on this bill and other bills. So I think it's entirely appropriate of.
I see, Anna, you're nodding your
Yeah,
head.
I want to weigh in too, because I do have experience working in Sacramento for the state legislative analyst office. And we as staff members were always in that position. We didn't express opinions, we provided analysis and background. And so to think that our commission couldn't be advisors or provide background information to the state legislature does not bode well with me. And so I understand the concerns of the public, but as commissioners, and if you look at the background of the commission, we have the ability to provide background information and analysis, and that includes the staff. So thank you.
Jane, you wanted to add something?
Yeah, I think that anyone who has, this is my second term, but I think that we've always tried to be, well, I shouldn't even say tried to. I think we have, at least during my for sure, during my tenure, we have always observed that bright line and not advocated, legislating. That being said, we provide support, we provide research, but we are not drafting bills. That's up to the legislator to do, and the approval to come from the legislative bodies. So I think, I'm not trying to discount what you were trying to say to us about your concern. I understand it. And maybe part of this needs to be a better communication with people who are speaking with us and about matters that are before us, exactly, again, what it is that we do and how we do it. Because we are very cautious and careful to make sure that we observe our marching orders, so to speak, and how we approach our assigned duties, because we are asked to do this. We are tasked to do this. We aren't spontaneously taking on these matters and advocating changes in the code. These are things that are requested of us to research and to give our insight. So that's my only point.
And also too, our role as a commission is very different. And I work as a temporary judge, and I have been for the last 4 years, and I'm very active with the LA Superior Court. So it's not so much as like where not all of us are forbidden to have ex parte communications with anyone. It's a very different role. It's an advisory. So it's kind of difficult to compare the two roles, Mr. Sir. But I'm like Jane, I can appreciate the concern. And it would be probably shocking to see Brian participating if you likened his role to one of judicial officer, but he's not. That's completely different roles.
One thing I'd like to add, and then I think Mr. Sir said Ms. Murray wanted to speak. Yeah, well, she just emailed me to the same effect. The provision that he's talking about, 8288, he read subdivision A, but that section was amended in 2020 to include subdivision B, which says an employee or member of the commission may appear and testify at any legislative committee hearing on legislation to implement a commission recommendation for the purpose of explaining the recommendation and answering questions posed by the legislative committee members, if the employer or member of the commission does not violate the restrictions described in subdivision A. So as long as we're not advocating for passage, we've been specifically directed by statute to testify at hearings to provide explanatory background. Ms. Murray is sending me a flurry of messages that she wants to speak, so I'm going to allow her to talk. So yes, you're on if you unmute yourself. Marjorie, you're there if you unmute yourself. And we've had problems with her connectivity in the past. I don't know what the issue is. Are you, oh, wait a minute, here we go. She's on the phone, hold on. Is that you, Marjorie? You wanna unmute yourself? Yeah, I can't do it. I can't, there you go. There you go.
All right. Just one by way of introduction. I have not sent a flurry of email messages. I sent one message asking to be able to make a contribution. Now, we have been testifying, as I think Brian will remember, for more than 20 years before the commission. So we are quite familiar with the commission mandate and its processes and how to participate. And it's very easy to visit the videotape from Thursday's Senate housing hearing to see how staff was introduced. Staff was introduced as the prime support witness for the bill, along with an association attorney, Mr. Dirk Petchel. They were the support witnesses immediately after Senator Min presented his bill. And the two prime support witnesses urged passage of the bill, and the way they were introduced was as support witnesses. And if commission staff was there in some other capacity, like being present in order to provide technical assistance or clarification, that would have been the opportunity to clarify when Senator Wiener said, we will now hear from the two support witnesses. So I just want to make that clarification. And I want to make a comment also on the legislative update memo. And that is, this I think is very important for the commission to consider when thinking about these amendments, at the topics for the amendments. The legislative status report makes no mention whatever of the analysis done by the Senate Housing Committee consultant. And as anyone knows who has worked on legislation, as we have for the past 20 years, the analysis done by a committee consultant is the prime tool for a committee to use, for voting members to use, and particularly for the chair to use in guiding his management or her management of the bill at a public hearing. And the analysis, which is 6 pages long, done by a veteran consultant, makes it very clear that the concerns raised by our center, by Habitat, and by the California Alliance for Retired Americans, that these were all proper subjects for possible amendments to be considered by Senator Min. These topics were not just mentioned in passing or listed casually. She devoted a full paragraph to each item. That is the recording of meetings, the proper notice to homeowners, and so forth. all of the concerns that we raised. So I think it's very important for the commission, when considering these issues, to get a copy, which Brian could easily provide to you, to get a copy of the analysis, to see what the consultant's perspective on the bill and on the concerns was. This is, I can't tell you how vital an analysis is. And there are several members of the commission who have just mentioned that they worked in the legislature, they worked for the assembly, they worked for the Senate. So I apologize for describing a process that you are already intimately familiar with, but that makes it easier for you to grasp the significance of it. That the committee consultant is not a person who rubber stamps recommendations or rubber stamps a bill. The role of the consultant is to do a brand new, fresh analysis of the legislation and of the issues, and to bring them to the attention of the committee members, to enable them to also think through the legislation, to enable them to vote one way or the other. And I think Brian may have mentioned this, but I'm going to mention it again. Those topics in the analysis were enough to keep 3 senators off the bill and to raise a discussion about the concerns. So these are genuine concerns that we are raising on behalf of our constituents who are homeowners, particularly low income, moderate income homeowners who are in affordable housing in common interest developments. And like Commissioner Sir, we were very, I'm not even sure what word to use, startled to see commission staff there in the role of prime support witness. That's exactly how they were introduced, and there was no correction of that role.
So the procedural concern is that I was introduced as a support witness, and I didn't say I'm not a support witness.
Excuse me, Brian, I haven't quite finished. So, well, in the memo, there are a couple of items of concern, the status report on legislation. And one is having a conversation with the chair prior to the onset of the meeting to coach the chair in how to respond to
that, Marjorie? Mr. Sir said that
it's
too.
on page 3. It's on page 3 of your memo. It's on page 3 of your own memo.
Where does it say that? Read me the language, please.
One moment.
Yeah, that did not happen. If I gave that impression, I apologize. I've never spoken to individual committee members about any commission bill.
Your memo says the opposition is based on 4 points. All of those points.
Oh, yeah, okay. I apologize. That was a typo. I meant the commission's chair. I meant Commissioner Miller O'Brien.
Yeah, he called me to discuss.
No.
Well, yes, I apologize. That was a typo. I should not have typed committee. I should have typed commission. It's a mistake I make now that the CLRC oversees both a commission and a committee. And I can see how that gave the wrong impression, but I'm telling you, I did not speak to the chair. I did not of the housing committee. I spoke to the chair of the commission.
Yeah.
And that's our standard practice.
And what we can do is we can do a correction just for the record, Brian, for the next meeting.
We'll put it in the minutes. We'll put in the minutes that there was a typo and make clear that I didn't speak to the chair of the housing committee.
And we'll also
the larger issue is the presence of commission staff at a hearing in a capacity other than being present as a technical consultant, as it were.
I wasn't present in any capacity other than that.
That is how you were in there.
You guys, I'm just going to get control of this meeting right now because I am chair of this meeting. And the back and forth, I don't find it productive, and it's not your fault though, Brian. What we can do is we'll issue the minutes for this meeting. We'll note objections and concerns. We can invite you to the next meeting, but we have commissioners here who volunteer their time essentially, and we need to make use of their time. And I am going to go ahead and ask that we go to the next agenda item because it's more of a he said, she said matter. I would recommend, and I'll do it myself, look at the minutes from the last hearing if it's a concern. And I do know and appreciate both Marjorie or Mr. Sir and Ms. Murray bringing this item or this concern before the entire commission. We do follow the Brown Act, so we don't meet outside of this unless there's a special issue. Like I have already confirmed, I did speak to Brian. He's a credible person. I would never even suggest that he's not telling the truth, but I am happy to go through what happened so that we can be prepared for the next meeting. But I move and I'll propose it to the commission. I recommend that we move to the next agenda item.
Second.
Brian's completed. Thank you,
Which
Commissioner
will be
Carrillo.
The first
Okay.
supplement, which Barbara's going to present.
Okay, Barbara, thank you.
Yes, this item is proposed for consent. This is the commission's bills on the California Public Records Act non-substantive recodification. There are two bills pending in the legislature. The one is to implement the recodification itself. The other is conforming revisions for the recodification. Those bills are now pending on the floor of the assembly. They went on the consent calendar. They went out of the Assembly Judiciary Committee on consent earlier this week. And we have had some stakeholder interest in the bills, but nothing that has led anybody to take any formal position on the bill at this point, either bill. The supplement that is before you today and the attached exhibit describe various purely technical revisions that were needed to update the commission's comments to the recodification and to update the commission's proposed legislation and comments to the conforming revisions recommendation. And the question at this point is whether those, as I say, purely technical revisions are acceptable to the commission.
Move approval.
You have full consent, Barbara.
Second.
Okay, well, that completes that memo. The second memo, a second supplement to the legislative program memo relates to the pending bill that would implement two of the commission's recommendations on trial court restructuring. Both of those recommendations involve repealing certain statutes. The supplement describes some conforming revisions of provisions in the codes that cross-refer to statutes that would be repealed. And the question, it's sort of a compound question for the commission, is whether whether the conforming revisions that are described in the memo and shown in the exhibit to the memo, whether those are acceptable to the commission. And if so, the second question is whether the conforming revisions should be incorporated into the commission's final recommendations, which have not yet been published. So it would be a simple matter to incorporate them.
Move adoption.
Move yes and yes.
Good. And Commissioner Rubin? Rich?
Second,
Okay, good.
approved,
Okay, good. And Jane, you're good. So you have full consent.
good vote.
Okay, well, that's it. So there's nothing more on those supplements.
Okay, let's take a break really fast. It's at 10:30 and we like to take a break ordinarily. So let's take a break and come back at what, 10:40? Are you guys, or 10:45? Okay. All right. Thank you. Brian, do you want to take us off the record? On break? Okay, good.
Can't hear you. Oh.
I'll put up a notice that we're on break.
Okay, good. Thank you. Richard? Oh, you fell. I was just going to tell you, you want to move your camera or take your camera off?